Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Manisha Patel presenting for us. If you are unfamiliar with the format of this event, first, Manisha is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or in the comments section on Facebook. We'll review all questions put in the chat boxes during that Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Be sure not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Manisha to get us started.
Okay, thank you, Marissa, and thank you all for being here. I'm excited to help you all learn a little bit more about a simple divorce in North Carolina. And I'm just going to start out to let you know that I'm going to use some terms interchangeably: simple divorce, absolute divorce, no fault divorce. Those three terms are kind of interchangeable. So if you hear me use one of those, I'm meaning the same thing and what you're here for today. Okay. So a little bit about legal aid and what does legal aid do? Legal aid is a statewide nonprofit law firm that provides free legal services in civil matters, so person to person, no criminal matters, to low income people to ensure equal access to justice, especially in the civil matters. Legal aid does a wonderful job to assist in removing the barriers and access to the court system, to justice, to legal answers for low income individuals in North Carolina. Here are some of the topics, some of the areas legal aid does assist individuals with: housing, employment, education, domestic violence, disaster relief, consumer, government benefits, veterans legal issues, human trafficking, Medicaid, Medicare, health, and other healthcare signups. So if you do have concerns or questions or issues about that, I'm gonna keep this slide on for just a minute. And you'll see this again at the end of the presentation, but if you want to jot down the legal aid website, and the basic intake phone number to apply for legal aid services, this is where you can get that information. And this is just a screenshot of the main legal aid or legalaidnc.org webpage, just so when you go there, you know you're in the right place. Okay, so some disclaimers about this presentation. As Marissa said, legal aid is not your attorney. This is general legal information. I am not your attorney. I'm a volunteer with Legal Aid of North Carolina for this presentation. And the purpose of this presentation is to help individuals, help you who are on the presentation, whether you're in the Zoom, you're on Facebook Live, wherever you are, or if you're watching this on YouTube later on. This is to help you prepare the paperwork and file your paperwork for a no-fault divorce in North Carolina. And it's to give you the tools and empower you to do this on your own. There is no attorney who will represent you in court. So this is informational. And again, if you have general questions, put them in the Q&A and we'll get to those at the end. Okay, I like to start these clinics, these sessions, presentations with a roadmap. I want you all to know what are we going to talk about today. So here's our roadmap. First, we're going to talk about if this is the right filing for you. Are you in the appropriate situation that you are ready to file for a simple divorce? let's say we pass, we say yes to all the questions. It's time to pass go to the next step. We're going to talk about what information do you need? What information do you need to gather in order to fill out the forms, to fill out the documentation, in order to file the appropriate forms, court paperwork, to get a legal action started in North Carolina, to eventually your goal being obtain an absolute divorce. Then we're going to talk about how do you do that? How do you file the forms? What does that even mean? I know as an attorney, those words are just regular common communication I use, but what does that mean for you when you have never done any legal action or never filed a lawsuit? What does filing the forms actually mean for you, and how do you do that? That's the actual important piece. How are you going to do this? Then at the end of the presentation, the last step, the last topic we'll discuss is how do you get that judgment of divorce signed? It has to be signed by a court official, meaning a clerk of superior court or a judge who presides over district court in the county where you have filed the lawsuit. So this is our roadmap. And so let's just go ahead and get started and start with making sure that this is the right process for you in your specific situation. Okay? Is this right for you? So if you are thinking, okay, my spouse and I are separated, I want to get divorced now. What do I need to do? The first question we ask, have you or your spouse lived in the state of North Carolina for at least 6 months from the date that you, at least 6 months before the date you file for an absolute divorce? Now, that or is capitalized because it's one or the other or both. So one, either you or your separated spouse or both of you have to have lived in North Carolina for at least 6 months, essentially to the day, before you file your lawsuit. That's requirement number one. If there's a no here, you cannot file. And if you do file, it will not move forward until you have met that 6-month residency requirement. What that is that is a personal jurisdiction piece of being able to file a lawsuit in this state. Okay, next question. Have you and your spouse been living separate and apart for at least a year and a day prior to the date you are filing? So let me break that into two pieces. Living separate and apart, what does that mean? That means you are living in two separate households, two separate addresses. You go to bed and brush your teeth in the morning at two separate addresses. You get your mail two separate places. And then have you been living separate and apart for at least 1 year and a day? In North Carolina, there's a requirement for a legal separation to be in existence. It has to occur for 1 calendar year. And I also want to put this in because I believe, well, actually, we just had a leap year in 2024, so we still have a few more years. But in the instance of a leap year, 367 days, not 365, or 66, excuse me, a year and a day. So have you been living separate and apart for at least a year and a day? And then also with that living separate and apart, the other piece that we don't really emphasize, but I want to make sure we discuss it, is one or both spouses have to have the intent, the mental state to continue living separate and to no longer holding yourselves out as a married couple. Now, if you're going to your kids' soccer games and you're all there, that's something else. But if you're having vacations together, if you're having family dinners together, that might show that there may not be intent to live separate and apart, with no intention to resume that marital relationship. So just keep those things in mind. Again, there are no try again periods. So let's say you're doing a trial separation and someone is just, you got an Airbnb for a couple of months to see, is this the right thing for your relationship, for your family? Let's say the other person moves back in, then your clock will restart at the next point when someone moves out. So there are no try again periods that will continue in that 1 year mark. And then this piece, I always try to emphasize that you are not to be living in the same house. That's separate and apart. That apart word means that you have separate domiciles. So if someone's living in like the garage apartment or in a separate bedroom in the basement, that's not separate and apart. I've even had a situation when someone lived in an RV on the street, not in the driveway of the marital home, and that was not considered separate and apart. So just keep those things in mind about that living separate and then living apart and the time frame. Okay, so let's go a little more into is simple divorce right for you? Okay, when you have an entry of a judgment of divorce, this will affect your property rights, which is the legal claim we call is equitable distribution, and it will affect your right or possible entitlement to spousal support. Spousal support, I use as a collective term for post-separation support and alimony. And as you can tell, these are things that involve your money. And so if you have questions or concerns about this before you file, I would implore you, I can't emphasize how much, to go talk to an attorney before you file anything for divorce, because once that entry of a judgment of divorce comes in, is entered by the judge, the clerk of court file stamps it, you can never make a claim for equitable distribution or alimony ever again, because those claims in the law are rooted out of a marriage. If the marriage has been dissolved, then there's no way to bring those claims again. Now, if you have those claims pending with the court and you get divorced, that's fine, because those claims will still continue to be determined through the court system, but they have to be filed with the court. Now, if you are interested in figuring out how can I make those claims and get my divorce, because I want to protect those options of property division and alimony, speak to an attorney before you file. If they can help you put those claims in, or even just help you draft the documents, that will save you so much time and heartache and probably more expense later down the road, so that those claims are protected. Later in this presentation, and I'm sure Marissa and I have been doing these for a little bit, so she knows what I often share, she'll put in the chat. So I think she'll go ahead at some point, drop in the lawyer referral service information. You can check with legal aid. Legal aid generally does not assist with those claims for property division and post-separation support and alimony. So the lawyer referral service is a cost-effective way to speak with an attorney who may, give you advice or kind of guide you what you need to do if those issues are something you need to consider. Okay, another common question we get is, does this affect my kids? What happens with this divorce? Simple divorce does not have any impact on child custody claims or child support claims. We have child custody clinics through legal aid to help you figure out how to file for initial custody action, but getting a divorce will not affect your ability to make claims for custody later on in the process. And then, as I shared, this has no impact on child support. So your children, and I'll use that children's issues collectively for child custody and child support. So just keep that in mind. This does not affect any children's issues, but it does affect your money. And so if that's a concern, I would again implore you to even seek an initial consultation. You know, an hour, 30 minutes will probably save you a lot of time and heartache down the road. Okay, let's go to the next step in our roadmap. Let's gather let's gather the information you will need to file your action for a simple divorce. Okay. Now, we broke this down into two categories. What information do you want to collect about yourself? And then what information do you need about your separated spouse? Now, we want your full legal name. I come across clients, people who ask me in consultations, well, my middle name is Jake, but my first name is William. Well, you want to know what is on your government issued photo ID, whether it's a DMV, like driver's license, an identification card, if you have a passport card, things like that are what we'll use to have like identification for yourself to see who you to say you are who you say you are. And so I always tell people during these clinics, what's on your driver's license? For example, I have my full like first, middle, last name on my driver's license, on my passport. If that's what you have consistently throughout, that's what I would say to use, because we'll have to get some documents notarized, and that's usually what a notary will look and refer to make sure you are who you say you are. Address, you want to have a mailing address that you're comfortable using. Most of these documents you are going to be serving to other parties. You're going to have your contact information to the court system. So they need to have an address where they can reach you. So your address, a reliable mailing address. PO box is fine. This is not required, but I think it's helpful throughout this process, a copy of your marriage license. Even if you don't have the actual marriage license copy in your hand, if you have a photo or a scan of it, that's helpful. Because in certain places you'll have to put your date of marriage, you'll have to put location of marriage. If you know those, don't worry about marriage license, but those are some of the things you'll need. You will need the full legal name and dates of birth and location of birth of all the children you share with your spouse. Whether you had a child together prior to the marriage, and then you got married and had two more little bundles of joy, then you want to have the full legal names of all three children, the dates they were born, and where they were born. And when I say where they're born, I'm not saying put the name of the hospital. You just need to know city and state. The state of North Carolina, city of Greensboro, for example. And then you want to know, where is the clerk of court's office in the county where you plan to file? Now, I want to kind of break that down just a little bit about the county where you plan to file. Your question might be, where do I file? I live here in Durham County and my spouse lives in Wake County. Well, how do I know where to file? You can file, and we call this under North Carolina law, it's called venue, like location. Where is the location appropriate for this lawsuit? It will be either where the county where you reside or where your spouse resides. If it's the same county, no issue. But you want to know where that clerk of court's office is, and it's typically in the courthouse. And so my best recommendation, and you will see this throughout this presentation, nccourts.gov is your kind of place, the website where you're going to find all the information. That's the website for the judicial branch, and you can search for your county on that website. You can search for forms. We'll talk about that in a little bit, but you want to be able to have access to their local rules and local forms, as well as just contact information. You want to know the address of the courthouse. You want to know if they have any instructions about parking. You want to know, do they allow cell phones? I know Guilford County just published a new order from our chief judges in Superior Court District Court talking about electronic devices. What is allowed, what is not allowed, whether you can have your Apple Watch with you or not. So definitely look at your courthouse page on nccourts.gov, and that will give you a lot of information. It'll give you phone numbers, a phone directory. So if you have questions, call the clerk's office, call the information desk. You will get that information through that website, and then phone numbers if you don't see that information on the website. Now, what do you need to know about your separated spouse? You want to know their full legal name and date of birth. At a minimum, you want to know their current address. Where do they go to bed at night? Where do they get their mail? Where do they sleep? That's going to be very important for service of this lawsuit. And we'll talk about that a little later on. And lastly, you want to know their military status. Were they ever in the armed forces? And when I say armed forces, Air Force, Coast Guard, Army, Navy, Marine Corps. Have they been in active duty in the National Guard? That's another one. So you want to make sure you know this. And if you don't, I would say you want to have their social security number if you do have that, because it will help you answer the question about their military status if you're not aware of it. Okay, other things you'll need. You will need a way to print all of these documents. You will be printing quite a few. I often say if you don't have a printer at home, or a friend or someone's printer you can print these papers on, I would say check out your public library. Typically, they might charge for certain number of printing pages beyond like 5 pages or something. But your public library will be a good place because they do most have computers with internet access. You want to know a location and have payment for a notary public. The biggest tip I can give about notaries are, if you have a bank account or a savings account or something with a bank or a credit union, any financial institution, check there first because they may do it for free. I know a lot of the big banks like Bank of America, Truist, Wells Fargo, I'm trying to think about their big banks. Even your smaller local banks like First Bank, Bank of Oak Ridge, more state specific credit unions, SECU, they all have notaries. And so you might have to call and make an appointment, but some just say first come, first serve. So check that out. I know other places you can get notaries for a cost at the UPS store. If you have other questions about the notary public, I would say go to the North Carolina Secretary of State website, and they have a whole directory of licensed, commissioned notaries who can notarize documents for you. And then finally, you want to have a location of a post office close to the clerk of court's office. So most clerks of court offices are going to be in your courthouse, and most courthouses are going to be in the downtown area. And so typically your main post office hub for your city or town will be in the downtown area or nearby. So check that out. Also, they're disappearing now, but a lot of places still have those blue mailboxes. Just be a little wary of them. There have been some issues with people taking mail out of those, and just some things where they don't go through the mail. So I always say go to a post office and just drop it off, even if you just drop it off in their mail slot. Okay, so we have all of the information gathered. You have identified where to get a notary. You have ways to print all your documents. The next step in our timeline are, how do you file? We're going to talk about the documents, the forms, but which option are we going to choose? So let's talk about that. First, you can download all the forms. Some forms are going to be located on the nccourts.gov page. They have a forms section, so that's one option where you can download some of the forms. There is the e-guidance file. It's through the North Carolina Administrative Office of the Courts, nccourts.gov, and they have a process where it asks you questions through an interview. You submit your information through the form, and then it pre-populates all of the documents for you. So I like that option because it helps you just make sure you include all the things that are required under the law. So you can download the forms through e-guidance file, fill out the interview, and then our other option is, I know Legal Aid has a wonderful file it yourself packet. If you feel confident that you just want to make sure you do it, you're not, looking at any website, you want to fill them out and handwrite it or type it in, Legal Aid has a file it yourself form packet. I call it a packet, and that will give you some basic instructions, but also some blank forms so you can see them and work through them at your own pace. And so you can download the forms from the web, fill out each form with a clerk and file it with a clerk of court, or the North Carolina e-guidance file, which is this, we say 1 hour, but if you have all that information in that we put in the prior slide, I don't think it will take you an hour. I tried to do that just so I can, I'm talking to everyone about this, so I want to know, how does it work? So I created a sample case with Mickey Mouse and Minnie Mouse, and did the interview just so I can see the process and I can talk to you all about the process. And so if you have all the information in front of you, it will not take you an hour. It'll be shorter if you have your time, all the information. You can download the forms and save them as like a PDF. I often say, if you do guidance file, create an account, because you can pause and then save your progress and then go back to it. If, let's say, you got all the information, but you don't have your separated spouse's date of birth or social security number, and you need to go back home, or you need to search your tax documents, your tax returns, to see if you can get any of that information. That's why I would say create an account so you can save your progress. Once you're done with guidance file and all the forms look good and correct, you can download those forms. Again, I say email them to yourself so they're saved somewhere, especially if you're on a public computer like the library, but you can print the forms when you're done. Once you do the final review of the documents after it pre-populates from your interview responses, you can download them as a PDF, and you can also just print them at the time. And then after you have all those documents and forms with you, you fill them out, you make sure you do the notary pieces, the signature in front of the notary. We'll talk about how that works. And then you file it with the clerk of court. Okay. I say file with the clerk of court. There are 2 ways to do that. So when we get to that step in the roadmap, I'll talk about those options as well. We're going to talk about North Carolina guidance file. Okay. So what does that mean? What does that look like? Okay, this screenshot on the left-hand side is what it will look like when you go to the eCourts guidance file. Okay, it's a free service that the judicial branch has created where you answer questions. It's that hour interview we talked about. It populates the form so you don't have to physically go type them in, and they've populate in the correct spaces, correct spot. So that's the helpful piece. And then you can print the documents to file with the clerk. So this is what on the left is a screenshot, and then on the right is some of that information I just shared and the link. And I do see that Marissa has put that link in the chat, as well as the legal aid forms packet, the file it yourself packet in the chat as well. So you have access to both, okay? So this is just going to be a simple walkthrough through the guide and file. You want to go through, the interview process. We talked about going through this step. Let's talk about downloading the forms, okay? So this is the link where you download the forms. It's nccourts.gov/document/forms. Now, if you are just going to nccourts.gov, it's really easy to find on the top bar, navigation bar on your right-hand top side. It's going to have a spot that says forms in all capital words, or excuse me, capital letters. You click there and it'll get you to that same page. Okay, let's say you're downloading the forms. What forms do you need? You need the complaint form. Now, this is going to be at the legal aid website. It's going to be the link to legal aid simple divorce packet that Marissa put in the chat. So definitely, I would say while you're on this presentation, click on that link, get to the form, and look through the forms if you can while we're talking about them. So you have the real-time comparison as I talk about it. You can see what I'm referencing. I'm very visual, so that helps me. So that's just a little tip as we move forward. Okay. AOC CV 100. That is the civil summons form that is required. This is what that form page looks like on the judicial branch website, the nccourts.gov. Once you click on forms, you want to look for form number. That red box, that spot is where you put this number of AOC CV 100. You want to put in the dashes, but that's where if you put in those that number, it will take you to a page where you download a fillable PDF. They do have some forms in Spanish to help you understand. If you need Spanish, you can download those forms and then transfer that information into the English forms. You want to go and get the domestic civil action cover sheet. One thing I will say about this is check with your local clerk of court, because some counties don't require it anymore. Since all 100 counties in North Carolina have gone live for e-courts with e-file and serve, e-portal, and guide and file, a lot of the counties no longer require that. I think it's good practice to just do it because it helps keep the court file organized, but follow the instructions with your clerk of court's office of what their specific requirements are. The Service Members Civil Relief Act declaration. It says affidavit here. The form has been updated, so it does not have to be notarized. But this is why in the information gathering stage, I mentioned about your separated spouse's military service or lack thereof. You need to know this because you have to put in the court file, is this person a member of the armed forces? And if they are they on active duty? And this is all reflecting federal law that, of course, North Carolina also observes and enforces, that any active duty service member of the armed forces, if they are on active duty, they are entitled to a court-appointed attorney to protect their legal rights while they are serving our country. And so this is really important. Definitely if you don't know if they're in the armed forces, but if they are, this is really important to include in your documents, because if it's not present in a court file, I've seen judges either remove the divorce lawsuit or not grant a judgment of divorce until that information, until that form is in the court file. So it's really important that you make sure you gather all these forms and you complete them and file them. Okay. Now this one is optional. I'll talk about it in a little bit, but a petition to proceed as an indigent. What that means is if you receive some form of public assistance like TAMF, food stamps, other forms of public assistance, you might be able to petition to the court to waive all of the court costs and filing fees. For absolute divorce, it is $225 to file a lawsuit for absolute divorce. And if you want to resume a maiden name or a prior married name, it's an additional $10. So if the finances, the court costs, or something that will be difficult for you to collect to save up to file this, you can do a petition to ask the court to waive those costs. And then with that petition goes hand in hand this affidavit of indigency. So what this affidavit does is it asks you, your name, your information, your age, your address, contact phone number, and then it'll ask you about your employment, other sources of income, and then it will ask you about your monthly expenses. And then with that affidavit, it must be signed in front of a notary. And then when you're going to file these documents, typically around that time or maybe a day later, the clerk of superior court will either grant or deny your petition. If they deny it, then you will have to pay the court costs. If they grant it for the duration of this lawsuit, all the court costs, filing fees will be waived, meaning you do not have to pay them. So if you think you may qualify for that petition, go ahead and download the document and read the instructions on the document, because it'll give you a little more detail than what I shared. And then again, make sure you check with your county about any extra forms they require. Check the local rules and forms section of your county's website on nccourts.gov. I cannot stress that enough, and I'll keep saying it. It's sprinkled throughout this presentation a number of times, just so if you miss the website, you miss what the special link is called. It's local rules and forms. Okay. So in the next step of our roadmap, what do we do now that we have these forms? Okay, you're ready for the next step of filing if you have all of these documents ready, filled out, signed in front of a notary, and if you have all the copies prepared. Okay, so the complaint from the legal aid file it yourself packet, you want an original and 3 copies, or excuse me, original and 2 copies. The domestic civil action cover sheet, if that is required, you want to have 3 copies of that. And then I apologize for not having this updated. eCourts is live in all 100 counties now as of I believe the last week of October or the first week of November. So some counties do not require it, but check with your county's clerk or your local forms and rules page, local rules and forms page, because they will have any updates on that. And then if it doesn't say anything, call the civil clerk's office. The county websites have a directory, a phone directory, so it'll be really easy to just click around on that web page to find the right phone number to call and ask. The civil summons, we mentioned that. I say at least 3 copies. If you think someone is going to be difficult to serve with the lawsuit, or difficult to locate, have more copies. I would say if you think they're going to be difficult to find, or they're going to avoid service of the lawsuit, at least 4 will be a good default. One note about the summons, it some require it to be the summons to be printed on yellow paper. They want 2 on yellow paper and at least 1 on white paper. This is rooted in just historical processes and procedures through the court systems of filing with paper, not electronically, and to identify which summons, because they're all the same, which one is going to the defendant, which one is going to be served to the defendant, and it's the yellow one. So I find in most of the counties where I practice that they don't care about the yellow paper anymore. So that's great for me, but I have a stack of yellow paper now in my office that is just there for fun. You want to look at the Service Member Civil Relief Act affidavit. You want 3 copies. And let me touch base about that real quick. When you get that form, you want to make sure that if you are uncertain about their military service, if they are on active duty, you knew they were, they enrolled in they joined the National Guard, but you're not sure if they still are, or did they get called up on active duty? The Service Member Civil Relief Act declaration, that form has a link to the government database. With that database, now this is why I mentioned having their social security number or birth date is crucial. You can search their full legal name, you can search with their date of birth or their full legal name and their social security number, and it will spit out a PDF of results, and it will go and show you if they're on active duty, are they service members? If they're on active duty, and then official language from the governmental database that you have satisfied the requirements under the Service Member Civil Relief Act. And so if you have that information, I think it's just always helpful and greater support to have the results attached to that form. And then again, we mentioned optional is going to be your petition to proceed as an indigent. And you want to have 2 copies of that, because that technically doesn't have to be served to the defendant, but the court will always keep 1 copy. So you will want to have a copy for your records. I always advise people, always at minimum, if it's not being served, you want 2 copies. So you always have 1 for your records. Okay, so filing, we've got all the right form. We know simple divorce is the right filing for you. We know all the information to fill out the forms. We've gone through the guide and file. We've gone through the legal aid packet. We've got all our documents ready. We've signed them in front of a notary public, and we have all the copies. What now? So we talk about filing. That was the next step in our roadmap. So what does this mean? How do we file? Where are we filing? What do we file? You want to make sure you don't sign anything early. So I keep mentioning that notary public. What does that mean? Why is that important? You want to make sure that your complaint, and that is the main document that has to be notarized. You want to make sure that you have all the copies of that document. Everything on that document is correct. If there's no false information, because that's a document a judge will look at when you're in court for your divorce hearing. And if they find out there is false information, there's a date of separation that's not accurate, that's not truthful, 1, that is not going to give you a good relationship with the court system, number one. Number two, they will dismiss your case and you're going to have to start from scratch all over again. And that means more court costs, more time away from work, and having to find a notary again, trying to make the copies again. So just make sure that all of your information is correct and that you don't sign your complaint until you are in front of a notary. And here's the other key. When you do sign the complaint in front of a notary, you have to be beyond 1 year from that date of separation. So that's why you heard me say a year and a day earlier. If you sign anything prior to a year and a day, they will dismiss your lawsuit and you will have to wait until you hit at least a year and a day and restart from the beginning. Okay. So now they have e-file and serve live in all 100 counties. So you can file all of your documents from your computer at home, but you can also do this at the courthouse. You can, I would say, block out about an hour because you never know how busy it may get. You want to make sure you have all of your documents, all of the copies ready. You want to make sure that you have everything in order and you have your court costs. Now, if you choose to file the petition to sue as an indigent, now that document, you know, I mentioned it's up to the court's discretion, meaning the clerk of court can make a determination. And so if they do that, what does that mean? Well, they can deny it. And so if you aren't prepared with paying the filing fee and you're already uncertain about being able to pay the fees, have the fee with you. As I mentioned, $225 to file a lawsuit for just absolute divorce. And if you are trying to resume a maiden name or a prior birth name, or excuse me, prior married name, it's an additional $10. Now, that piece, resumption of a maiden name, you can do that later also, but it just makes things pretty simple and straightforward if you do it with the divorce. Once you have everything ready, let's say we didn't do the petition to sue as an indigent, we are going with all of our documents filled out, we have the court filing fees, what happens? Well, the clerk of court, so some counties have family court divisions, and they will have their own separate office at the courthouse. Some will be with the civil division of the clerk of superior court. So if you are in doubt of where to go, first, I always say call the courthouse, call and ask, where do I go for the civil division to file for divorce? If you call, say that, they're going to tell you. When you're on your nccourts.gov website for your county, let's say from the earlier example in Durham County, go to the phone directory, find the civil division phone number, and just give them a call. They'll, you know, they want to make your life easier because ultimately that makes their job easier. So they will surely help you with where to go, and if you forget the actual court costs, they can give you that information. The one thing to keep in mind, though, is they cannot give you legal advice. For the most part, clerks of court, when I say clerks of court, deputy clerks of court, assistant clerks of court, they aren't licensed attorneys. And even if they are by their job, they're not allowed to give you legal advice. So if you have questions and you need legal advice, I would say contact legal aid to see if someone can help give you an answer, or reach out to the lawyer referral service and see if they can help you figure out what the issue is. Once you have everything ready, you give it to the clerk. They will make sure they have everything they need. They will open the case in their system and they will assign a civil file number. They used to be called CVD numbers for civil district court. Now with our e-court system, they just label them 2026 CV, and then the second half of the number, the 6-digit number, will be whichever number case is filed in this calendar year in the civil cases. So they will assign that second half of the number, file stamp everything, and then hand everything back to you, because the next step is serving the defendant. Okay, now this one we're going to spend a little more time talking about, because there are a lot of nuances, and I'm sure we're going to have some questions. I know a lot of common questions that come up, so I'm going to try and go ahead and answer those before we get to the Q&A session. Okay, so we're the next step in our roadmap of serving the defendant. What does that mean? A lot of people think serving the defendant, serving someone with papers, means what you see on TV, that there's a process server, a private investigator, someone that comes up to a person at work or on this, going to lunch and handing them paper and saying, "You've been served." That's an option. It's not as dramatic as the media portrays. We're going to talk about these 3 options, these 3 methods of service. And the reason I include this last option of publication is because our laws say you can't jump the options, jump the gun, and go to publication as a service method right away. You have to make what they say reasonable efforts, and most courts I find define reasonable efforts as at least 2 different methods that are applicable under North Carolina law. So our first option, sheriff. $30 by any county sheriff's department in North Carolina. Or that's the person-to-person service. Then if you want to hire a private investigator or a process server, that's another option in category 1 of similar to a sheriff. We always recommend sheriff because it takes it out of your hands, and it's the most cost effective. I like to help people not spend excess money that they don't need to, when this whole process, this whole life transition, is an expensive time anyways. Certified mail with return receipt requested. Now, what that means, and you can probably see a little bit, I know I have my background blurred, but it's this green and white card where it's for certified mail, and then this light green, I call it mint, maybe seafoam, that is the return receipt requested. And the reason both are important is because certified mail means it's insured and it's tracked, and return receipt requested is your proof. It's your proof that the defendant has signed this document, and it will just be put back in the mail to you. This is your proof that they received it, and they're required to sign and date on here, so you will know their exact date of service, because that's going to be really important. But the main thing is you need their signature. You need to know when they signed it and their signature. And I used to say certified mail return receipt is always like my first recommendation, but post-COVID times, and I know we're almost 6 years past when we had the shutdowns in March 2020, but sometimes I still do find that USPS will put COVID or no signature and send it back. And then you've just wasted this time to do this process, when a sheriff more likely than not will be able to get the papers served. So the difference is certified mail with return receipt requested. I just did this, I think, on Monday, and it was $10.44. So the main differential is certified mail is a little risky, but it's a lot less expensive than the sheriff. Now, let's say And I put FedEx or UPS. Those are going to be more expensive, again, around maybe $50 to $75. And then if someone lives outside of the United States, I find that DHL, it's another mail delivery service like FedEx and UPS, but I've had the most success with service of a defendant in a simple divorce lawsuit through DHL. I've done it for people living in Sweden, in Germany, in Italy, in Philippines. I just did this at the end of last year in the Philippines, and no problem. International, of course, is going to be even more expensive. It was about $120, but it cut out the stress of trying to locate someone in the Philippines. And then let's say you've tried all these methods. You've tried Sheriff, you tried FedEx, nothing has come back with it served. You want to go to publication. Now, what is publication? We'll go into the details, the nuances of that, but let's go a little bit about what are we serving the defendant. We're going to serve them with one complaint and one summons. Now, let's put a little asterisk by the one summons, because when you serve by sheriff, you need to give them two copies of the summons the clerk has signed. Okay. And I mentioned this kind of throughout, talking about the different ways, the different methods, but there has to be proof of service, of process. Process is what the legal term for the complaint and summons. There has to be proof in the court file that the defendant was actually served. Now, how do we make that actually served? Well, the first two options, the sheriff will get the defendant to sign the backside of the summons, and that's why they'll get the defendant to sign on one of the summons. The defendant gets one copy of the summons. The second copy of the summons, they will have them sign and they return it to the court file. So that's the proof. We'll talk about how does that proof get in the court file for all these different methods, okay? Okay, let's go into more detail about sheriff. Now, sometimes the sheriff's office is going to be in the courthouse. It might be across the street from the courthouse. And that's something else. If you want to go serve by sheriff, if you choose that option, do a little homework before you go to file all your documents to find where is the sheriff's office. Can I walk there? Where do I park? Different things like that. I don't know what I just did to zoom that in. There we go. Okay, here we go. Oh, it just did that again. I'm so sorry. Give me 1 second. I am so sorry. I don't know how I zoomed that in.
Maybe stop sharing. Reshare.
Okay, yeah, let me do that. I am so sorry. I don't know how I am so sorry, you all, how I got that zoomed in. Let's go back. Okay, there we go. I found it. Sorry. Okay, so we went through this slide. Let's go to the next slide. There we go. Sorry about this. Okay, you can go to the sheriff's department and ask for the service civil process department, and that is what the magic words. If you are calling the sheriff's office and want to figure out what are their procedures, ask for the civil process department, and they might transfer you, or you might have someone who handles those issues, and they will give you their instructions, and that will also be, the person you call back to check status. You want to give them one filed copy of the complaint and two of the civil summons that the clerk has issued, that they have put in the date, the time, the court file number, all of that. You want to make sure they get two of those. And again, remember, that's because the defendant will keep one, and then they will serve the defendant with the clerk's office. They will give the clerk's office one back with the defendant's signature, the date, and the address of where they were served. So that's why two is important to give the sheriff's department. As I mentioned, the $30 service fee is paid to the sheriff's department directly. If you have the petition to sue as an indigent and the filing fees have been waived, and they're not going to charge you service fees, then you don't have to pay this cost either. So if the costs do add up, and so just be mindful about that. If you truly can't afford the cost, there are options that the court system does not want to bar you, does not want to give you a barrier to get a divorce. Okay. Now, the deputy who serves the defendant will note the date, time, and address on the back of the summons. They will sign it. They will send it back to the clerk of court. And how do you find out if the defendant has been served? Well, the easiest way is making sure you have your court file number that the clerk has put on all your documents when you went to go file everything. And then you call the sheriff's department back, ask for civil process, and give them that number. Once you give them that number, that's the way the court system will identify your lawsuit. And so that's where you want to check on them. Now, if you're comfortable with the e-court system, the e-file and serve and e-portal, you can log on to the portal and put your court file number in, and it will pop up a summary of the court actions, and you will see when the sheriff's department returned the summons to the clerk's office to process, to say this person was served or this person was not served. So there are a couple of options there for you to figure out if the sheriff's deputy was able to serve the defendant. And why I emphasize this so much is knowing the date, whether you do certified mail, whether you do sheriff, any of these other methods, you want to know what date the defendant was served, because they have 30 days from their date of service, from when they received the papers, to file a response. Okay, certified mail return receipt requested. So like I showed you before, you have these papers. I keep extras at my office. They have them at the post office. And if you don't know how to fill them out, just go to one of the postmasters, one of the teller desks, and they're just wonderful people. They will help you, fill out the forms, put the right information in the right spot. Like I mentioned, I just did this on Monday, and it was a little under $11. If you're sending a lot of documents, it might be more, but it's pretty straightforward. What you want to do, again, one filed complaint, one summons in an envelope addressed to the defendant, and you want to use the address you put on the civil summons. That's the most important piece, because that's how the court system is going to locate the defendant. Okay, I know I typically get a lot of questions about, what if I can't find the defendant, or the defendant moved out of state, or the defendant left the country and I don't know where they are. We'll talk about those different options, but you want to put the last known address, the last known domicile of the defendant on the civil summons, because that's the address where the sheriff will go, and that's where you want to send these documents through certified mail return receipt requested. Okay. I mentioned the green and white card. You want to pay, you fill out the certified mail receipt, and it will break down the postage cost. The postmaster, the teller at the post office will fill that piece out. There will be a tracking number. I would definitely say write down the tracking number or take a picture of it. I always like to take a picture and save it like in my notes on my phone. That way I have the picture, and then I have the number in my notes in case something accidentally gets deleted. But then you can search on USPS.com tracking. You can look at the actual progress with this tracking number on the certified mail. Where is it? Has it been attempted to be delivered? Has the defendant picked it up from the post office? Have they returned the return receipt? All of that will show you that log. And the reason that's so important is because of the affidavit of return of service by certified mail. So again, we talked about how does the sheriff's service proof get into the court file? Well, now we're going to talk about what is the proof from certified mail that goes into the court file. So this is like a screenshot of the document that's in your self-help packet, the legal aid simple divorce packet. And it's going to, you're going to fill this out, but remember, it's an affidavit. It's a sworn statement. So you cannot sign it until you're in front of a notary. Okay. You want to fill this out. You want to list what address who you sent this to, the defendant. You want to put in the defendant's address that you mailed it to. You want to put in the date the defendant received it, and then you want to attach the mint green card, the seafoam colored green card that comes back to you in the mail. You want to attach that to this affidavit. I often say it is the best practice to print out the tracking history from USPS.com. Once you go to tracking, plug in the tracking number, it will give you a detailed history of the traveling, essentially. Every time the USPS has scanned this barcode, they will show what date, what time, what location it was scanned, and then it will ultimately show when that person, the defendant, signed the green card and when it was scanned back, because the tracking number is on both of these documents. Okay, you want to attach that to this affidavit of return of service by certified mail, the green card and the tracking history, and then take it to a notary. Again, I would say you want the original one for the court file, and then you want one for yourself and one to mail to the defendant. And then now, once you've, when you mail it to the defendant, you've already served them through certified mail. So you just send it first class with one of those cute little forever stamps. That's fine. As long as you've done this original service, proof of service, regular USPS mail afterwards is completely fine and acceptable. Now, third option. Let's say you and your separated spouse separated obviously a year ago. You're both in communication because you're amicable and you both want this divorce to be done. If they are willing to accept service, hand them a copy of the filed complaint and the civil summons, and then this document is a document that they will sign saying they don't waive any other rights other than they are accepting the service of process of these papers. And then the date they sign this affidavit, or excuse me, this acceptance of service, which again has to be notarized. So they have to take some effort to do this. They have to go to a notary. When they do this, that that date that they have signed this becomes the date they are served. So remember, each option we talked about, how do we know what day they're served and why is it so important? So that's the date. If with this method, you need to keep in mind and have that just like circled on your calendar. Okay, publication. I mentioned this briefly on that first page about the different methods. This is common where and I'm going to give you an example, like on TV, on legal shows where someone says, I'm going to put this notice in the newspaper. I'm going to embarrass this person. I just want the world to know that they're missing in action and they're avoiding service. I'm putting in the newspaper. Well, like I said, you can't jump to this option initially. It is a means of last resort, okay? Truly. Now, if the court has, you're in court for your divorce hearing and they only see that you've served by publication, they will either dismiss your case, they will take it off the court docket, make you file a notice of hearing again, pay another $20 fee after you have attempted reasonable measures to serve the person, like actually, so they have the papers in hand. Okay, so you must make those reasonable means to find the defendant. Now, again, with these clinics we've done, we get a lot of questions about, I can't find him, I can't find her, they just disappeared, they left me, left the state, and who knows where they are now. Your reasonable means to find the defendant, it could include, one, service by sheriff or certified mail at the last known address. Like I said, the last known address, last known domicile, where do they sleep, where do they get their mail, where do they brush their teeth at night, and where do they make dinner? Those are some of those types of questions I ask when we're trying to figure out what is a person's domicile, where's their last known residence. Okay. Internet search. You would be surprised what you can find on the internet these days. I know I constantly am surprised what I find on the internet. Maybe you're not, but every day I learn something new about what's out there and in the world of the internet. Contact any family or friends of your separated spouse that you may still have communication with. Oftentimes I think like Facebook message, Instagram DM, something like that to a friend, a mutual friend, or a family member might be helpful. And again, I'm going to say, if you feel safe and comfortable doing this. Oftentimes I have people who've experienced domestic violence. They don't want to share their information. They don't want to open that can of worms after you've had, a year of separation. So there are different ways you can do this. You can check the DMV information if they have a vehicle, see about their vehicle registration. And then another option, again, this one's going to be a little more expensive, is hiring a private investigator to locate them. Now, if you do work with a private investigator, I think it will be helpful to make sure they know all the information you do. If you don't feel comfortable contacting family or friends because of some interaction, domestic violence, whatever it may be, maybe that private investigator can make those contacts. But again, you're paying someone for this service, so it will be an added fee, and it's not included in that petition to waive petition to sue as indigent to waive court costs. This is not included if you have to pay a private investigator. Okay. And then again, check with your clerk of court to see if they have any other local requirements before using publication. Some, some say our judges want to see at least 2 different attempts. They want to see 3 attempts. They can't give you legal advice at the clerk's office. So if they do, just be wary of it and double check with a lawyer. But for the most part, they, most people who have been working in the courthouse system, courthouse personnel are so skilled and experienced because they know the processes. They will say, if you tell them, I have X, Y, and Z documents, am I missing anything? They might say, oh, you need to get that service member Civil Relief Act document. But yeah, we'll go ahead and file everything. But they can't tell you how to fill out the forms. They can't tell you anything about the process beyond, yes, I can do this for you, or no. And so just keep that in mind. Sometimes there are local legal legal aid resources locally, or they might have information about the lawyer referral service. So those are just some options if you want to double check and, let's say, make sure you filled out all your forms correctly. Okay, so we're now in the spot of, let's get our entry of our judgment of divorce. It sounds so final, sounds kind of scary, but it's not. There are different ways you can get a judgment of divorce. Okay, let's talk about some of these different options. Okay, option number 1, you can get a judgment of absolute divorce before the clerk of court. That's one way. Now, if you have not gotten a response from the defendant, you've served them, their 30 days have passed, I would say probably, if your county does this, if they do allow the clerk of superior court to enter divorces, try that option. I know some counties, some judicial districts do not do this. They say you have to go in front of a judge, and that's just their process. Then follow that process. An uncontested testimonial divorce before the judge. So that's the option we're going to talk about, because more likely than not, that's going to be the option that you are faced with. Whether someone shows up, whether they've filed some document in response to your complaint, if they lawyered up and they hired a lawyer. An uncontested testimonial divorce before a judge is going to be a more common option. So let's talk about that. Okay. Again, I mentioned this, the process, the procedure varies from county to county. To schedule your testimonial hearing for a divorce before the judge, they have different courts have different requirements. They have some only hear the absolute divorce on Mondays at 9:30 on WebEx. Some may only do it Mondays at 2 p.m. in courtroom 4C. There are different requirements. And so I, again, implore you to contact the clerk of court or family court to determine if they have specific local rules or forms or customs that are applicable to that county where you filed your lawsuit. And then again, as I said from the outset, I'm going to tell you over and over to check your local rules and forms page on your county's website on nccourts.gov. Okay, so let's say you have to file or have to schedule that testimonial divorce hearing. That's where that $20 notice of hearing fee will come into play, that I mentioned is one of the court costs that could come up. So we're going to have a hearing in front of a judge. And what does that mean? That means at a certain day, certain time, you will have to go to the courthouse, sit in the gallery in the open area on the back of the courthouse or courtroom, and wait for the judge to call your case. Now, how they call the case is going to be last name. So if we're at Mickey and Minnie Mouse, it's going to be Mouse v. Mouse is what they would call. And you just, when they call your name, stand up and say present or here. And that way they know that to go on to your case when it comes on the schedule for that day. Now, we've talked about why is that date so important that the defendant signed for the papers the day the sheriff handed the defendant their complaint and summons, the day that they signed the acceptance of service. The reason that date is so important is because they get 30 days from the date they were served before you can do anything. They have 30 days to respond. Now, they do have the ability to get an extension of time, which can be an additional 30 days. So that's why I say if they don't respond to anything after 30 days, it's just a matter of when you can get this hearing scheduled. Now, let's say they did not do anything, you hit day 31, you can contact the clerk's office at that time to see how can I schedule my divorce hearing? What is the earliest date through the court's procedures that I can schedule this? They can tell you over the phone, but you will have to file a notice of hearing. And again, I will say from experience, different counties do have different forms called, some call it a notice of hearing, some call it a calendar request and notice of hearing. Some places call it, some counties call it notice of hearing and calendar hearing request. So look at the, again, local rules and forms page. The form, if there is a form, should be up there. And if there's not, contact the clerk's office, check the directory, call the civil division or the district court judge's chambers office or that number, and ask for the calendar clerk. And they will help you with their special deadlines that you have to file 2 weeks before. Whatever their specific requirements are can help you do this the right way so you don't have to start over again. What you'll need to do is this calendar request notice of hearing. Unless the filing fee is waived, it is $20. And then you want to have a certificate of service for the notice of hearing. Again, when I say, this notice of hearing form is often a local form that different counties have, and it's their practice that you have to use this form. Just check. Sometimes they'll include certificate of service language on the document and you don't have to do a separate one. But if you do, make sure you fill that out and file that with the court. Now, if they have, again, like I said, I'm going to have this on practically all the slides now from here on out. Check with your local clerk of court for the actual process, if they have different forms that are required, and then you can call them or check the website on nccourts.gov for your county. And then for this, you will need 4 copies of any document before you are filing for a hearing before a judge, because you will have to serve the defendant a copy of the notice of hearing, the calendar request, whatever they call it, and the certificate of service. So you want to make sure that they have received notice of that hearing date. I say 4 copies because I always want to have an extra copy, with this being very, very important. The notice requirement under our North Carolina law, you don't want to take any chances with all this work you've done on your own, and you should be proud of yourself to get to this point that you've done all of this on your own. Having extras at the end of the day is just going to give you some peace of mind that in case you need to send it again, or the mailing address is wrong or they moved, you have an extra that you can serve the defendant. Okay. Now, how are we serving the defendant with the calendar request, notice of hearing, and the certificate of service? You will have to put it in an envelope, regular first class USPS with the forever stamps. And then each of those documents, basically anything you file with the clerk's office, you have to serve to the defendant. They need to get a copy of it. So most commonly, I tell people if you're doing this without an attorney's assistance, you can send through USPS mail, that forever stamp 1 ounce first class mail, or you can serve them by email or through e-file and serve. Now, if you have gone through this process, you're familiar with our e-court system and you want to do it through e-file and serve, you can do that as well. We just did not go through the nuances of that process here. Okay, notice of hearing. Let's talk about that, because that I mentioned very briefly about how it's really important that the defendant has notice of the divorce hearing. And if they don't have the prerequisite notice requirement under the law, a judge can remove it from the calendar and make you recalendar it. Those are just some words a judge could use, and that's another $20. Or they can continue the case for another month, another 3 weeks. They can continue the case and make that decision that the defendant does not have notice of this divorce hearing. Under North Carolina law, they need at least 5 business days prior to the hearing, and we do not count weekends or court holidays. So if, let's say, you are mailing something today, today's Thursday, so you have Friday. We're not counting Saturday or Sunday. Monday is a court holiday for MLK Day, so we can't count those 3 days. So we're looking at Friday, we have Tuesday, Wednesday, Thursday, next Friday. So next Friday is your 5 days of notice for the defendant. And then if you mail it, they get an additional 3 days. If you do USPS, we call it the mailbox rule. So then you have to wait again. We're not counting weekends. So then you have Monday, Tuesday, Wednesday. So in theory, you're going almost 2 full weeks to make sure they have that 5 business days of notice. So sometimes that can get a little confusing. If that's the time you need to get help with a lawyer referral service to help just make sure you've done the right amount of days, that's a great idea. Oftentimes I find when I go to various different counties for an absolute divorce that they have filing deadlines, and those filing deadlines are maybe 2 weeks prior to a hearing date or a month before the hearing date, and it's kind of built in time. So let's say you do the calendar request and your court deadline is today for it to be heard in 3 weeks. That's more than enough time with the weekends, with the federal court holiday, the state holiday, excuse me, to make sure they get their notice. And so when in doubt, I always say, throw in a few extra days. If there are no deadlines that the court requires, that's like 2-3 weeks in advance, just give yourself an extra week. I think that's really good to just give yourself some insurance before you have your divorce hearing. Okay, so your testimonial divorce, the day of court, what do you need to take with you? First, make sure you know the court's rules. If the courthouse does not allow cell phones, smartwatches, computers, laptops, iPads, tablets, leave them in your car, leave them at home. Some courthouses have little like lockers outside where you can put in a quarter and put your cell phone in there. If you feel comfortable doing that, do that. But just, again, check their website on nccourts.gov. That information will be posted there. And again, if it's not, call. In your self-help or file it yourself packet from Legal Aid, there will be a judgment of absolute divorce form. And you also want your certificate of absolute divorce or annulment. And that form is AOC CV 11. And that's where at the very beginning, when we talked about downloading the forms from the judicial branch website, you can download that form there. And then I always say it's a good practice of when you're going to court, go ahead and have that stamped envelope there for the defendant's address on it, so that when you get the judge signing that judgment of divorce, when you get that certificate of absolute divorce or annulment, you take it with you from court, put it in the envelope, you get all those documents file stamped from the clerk after the judge signs it, and then drop it in the mail as you leave the courthouse. Stop by the mail, a post office, and just make sure you get it to the defendant. Now, if the defendant is in the courtroom as well and they show up, you still need to do all of these things, but you can hand it to them. At that point, you can leave it in the envelope and then just hand deliver to the defendant. Okay. Again, you want to fill these forms out on the computer and print copies. If you don't have access to a computer, again, go to your public library. I discourage people from doing this on their smartphone, their like mobile device, because sometimes you might miss things and it like might jump. You're, Verizon right now, everyone's dealing with a cellular service outage. You don't want to be in the middle of doing these forms or the guide and file interview, and then you have no service. You're not near internet, and you don't even know if you saved your progress. So I always say, I call it big internet. Get on a computer, go to the library, and get everything filled out and printed. Okay. Legal Aid's self-help packet, the file it yourself packet, only has the forms, not sample forms. So they don't have examples, but it's pretty self-explanatory. So these are the main things to prepare for the hearing. Now you're at the hearing, you are at the court date. What do? You want 4 copies of the judgment of divorce filled out and the certificate of absolute divorce. They are going to be in your guide and file packet, as well as the legal aid form packet. And these are important because the judgment of divorce form that's filled out before the judge signs it, that's going to be your guide in how to answer the questions the judge will ask you, okay, during the hearing. So, dress. How do you want to come to court? I always say, come to court in business casual, like you're going on a job interview. You just want to put your best self forward in front of the judge. Judges will have the bailiff take you out of the courtroom if you have untucked shirts, your pants are hanging low, hats, religious head coverings are acceptable. If you have offensive language on a t-shirt, they will send you out. I've seen it happen multiple times. So just put yourself together because you'll be talking in front of a judge. As I mentioned, most courthouses do not allow cell phones, electronic devices. So leave it in the car, at home. Some courthouses have those lockers. So bring the quarter if you know they do, so you can put that in your in the locker while you're in court. I arrive at least 15 minutes early. For example, when they say court starts at 9 a.m., court starts at 9 a.m. That's when the judge will come in, the bailiff will make everyone stand, they will open the court, and then the judge will sit down, everyone else sits down, and then they will start calling the schedule of the cases. We call it a docket. They will go through and go through all the cases scheduled for that day, and that's when you hear your name, you stand up and you say, "Present, Your Honor," or "Here." If you have an attorney, they should be there, or they should have communicated with you about what the plan is. But also, I would say plan to get to the courtroom 10 to 15 minutes early. But if you have questions about parking, or they have security lines that you know from when you came to file everything, plan extra time. 30 minutes is a good measure. Parking decks often confuse me. So if I know I have to park in a parking deck at a different courthouse, I'm going to give myself an extra 15 minutes so I can find a safe parking space and walk to the courthouse. And then you just sit in the gallery once the courtroom is open and then wait for your case to be called. And then when your case is called, you want to approach, I say the judge's bench, the tables where typically you see the parties and attorneys stand or sit. And then if you don't know which one to go to, just ask the sheriff's deputy, or the judge will be happy to tell you where to go, where to stand if you aren't 100% sure. Sometimes the judge will ask you to take the witness stand. If there's a defendant isn't there, they may let you testify from the table, the party counsel table. They will swear you on the Bible, and if you don't want to do that, they will affirm you. And then after that, they'll let you present your case, or some judges will ask you questions if there's no one else, like the other party isn't there. And then when you're testifying, you want to speak slowly and clearly. I'm a person where a lot of times my mind runs a mile a minute, and then my mouth is going probably 30 seconds a minute. My mind goes faster than my mouth, and I get jumbled up sometimes. So I do this thing where when I sense that happening, I take a deep breath and then get oxygen to my brain, and then I open my mouth. There is nothing wrong with taking pauses, taking breaks. If you need to take a break and you think it's going to be more than like a couple seconds, just let the judge know that, Your Honor, I need a minute, and you're looking at your papers as your guide. They're going to give you the time to get yourself together. And then, as I said earlier, use your judgment of divorce as your guide for testimony, because the questions that a judge may ask or the things they need to hear is going to be on your form judgment of divorce. And so when I say that, what is that? So here's a screenshot of a judgment for absolute divorce. What this is, this will say plaintiff is a resident of Orange County. I think in my example was Durham County. Defendant is a resident of Wake County. Then it's going to go through, ask, various questions about the case, about what you put in your complaint. It's going to be in your guide and file packet. It'll be in the legal aid file it yourself packet. Again, make sure you take 4 copies with you to court. If the judge grants your divorce, he or she may ask you for it, like physically, so they can sign it. And so the process might take a little longer with the e-court system, because they'll have to scan it in, electronically sign it. Then the clerk will have to file stamp it. So just make sure when you go for this, you plan enough time for this to get done or to be completed. And then, like I said before, you want to make sure you mail a copy to the defendant of the judgment of absolute divorce once it's entered, and then also the certificate of service through USPS mail. You can hand deliver. You can, I think USPS mail is probably just like your safest and easiest option. It's going to take one stamp. Okay, now this is what you'll see from your guide and file forms for the certificate of absolute divorce or annulment. Okay, in this example, you'll see a blank over here by file number. You will want to fill that out with your court file number that the clerk assigned when you first filed all the documents, when you filed the summons, the complaint, all of that. When you get your court number, that's where you put for file. And then you fill in the information here, the marriage information, date of marriage, location of marriage, if you have any minor children, and your date of separation. Oh, going a little too fast. And then this certification, there's a little section underneath that that's cut off from the screenshot, but that is under certification is where the clerk of court will fill the remaining information and then sign the certificate. So once they sign it, they will also send a copy to the Department of Health and Human Services of North Carolina in North Carolina Vital Records. So there will be an official record in the state registry, state records of, marriage license, divorce, certificate of divorce, birth, death records. They keep divorce records as well. And so this is the document that will be in the state registry to show your date of divorce, because in that certification, the clerk will fill out a date of divorce. Okay. After the hearing, you've gone through all of this, you killed it in court, you said everything, the judge was happy with all the information, they saw the defendant had noticed, you filled out the judgment, you handed it up, they signed it, the clerk file stamped it. What now? The judge will make sure that you have said everything on the record that is required under the law for a divorce, an absolute divorce. And if not, they will ask you questions. And it's just a conversation. Just like we're having a conversation today, like a conversation you have with a coworker or a friend or a boss, you're just having a conversation with the judge. Okay. They'll look at all the court documents, and that's where they will make sure that service member Civil Relief Act document is in there. They will make sure the defendant had notice of the hearing. They will make sure the defendant was served with a lawsuit. So they'll look for a sheriff's service, affidavit of service by certified mail. They'll look for all of that. And then you want to, like I said, you want to make sure they have a copy of the certificate of service for the judgment of divorce and the actual judgment of absolute divorce. You mail those to the defendant. You want to make sure that certificate of service is filled out, so while you're at the courthouse, the clerk can file stamp it. And then in one envelope, put both documents and mail it out to the defendant. I always say keep a copy of the entered judgment for absolute divorce in a safe location with your important papers. Important papers are like your car title, your deed to your house, any mortgage documents, your will. If you have a power of attorney where you keep all those documents, just keep a copy of your judgment of absolute divorce. And nowadays, I often counsel people to say that having a certified copy is going to be crucial. So the court cost for a certified copy is $3. And why is that important? It's important because, especially number one, if you are resuming a maiden name or a prior married name, you will need a certified copy to go to the Social Security office to update your name. You'll need it for the DMV, the North Carolina DMV, to update your driver's license. And then once you have those two updated, you can go to your banks, your credit card companies, your employer, your doctors, all medical providers with that certified judgment of divorce and let them know that your name is legally changed and they need to update their records. So I just say, if you can, get a certified copy, and that way in the future you will not need to worry about it. You have one, and it's in a safe place with all your other safe documents. I think it's just a good practice, and it relieves any headache in the future if you might need it, if someone might request it. And so maybe 2 copies of the certified judgment. I say 1 now because through the eCourt system, they send them electronically and you can just print it out as many times as you need. There's no raised seal, wet certification. It is an electronic certification. So I think 1 is enough now because all the counties are in eCourt and they do the electronic certification. So there's not really a need to get multiple certified copies, but the other side might want to get one. But for you, one should be enough that you can print over and over if you do need it. And then with that, the presentation's done. This is the contact information from earlier in the presentation for legal aid. If you need additional services beyond this clinic, I am going to turn it over to Marissa for any questions.
Perfect. We do have a couple questions, though I do think you answered a lot of them throughout the presentation. So I'm just gonna have to kind of hit back on them really quickly.
Yeah.
Someone just wants to make sure they can change their name during the simple divorce process. That's something they can ask for with their simple divorce as a name change.
Yes. Yes. And so I tried to be consistent as I was sharing that. You can resume a maiden name or a previously married name. So if this is like a second marriage and you want to go back to your last name from your first marriage, you can do that. But it's not a matter of, okay, my last name was Jones and it's so common. There's a Susie Jones in my, my job. I want to change my name to Susie Campbell. You cannot just make up a name. It has to be either your birth name that's on your birth certificate or your prior married name. So just keep that in mind about the name change. And it is $10 court cost.
Someone's asking if they got married in a different state, but I guess, and I'm assuming have now lived in North Carolina for that 6 month period or whatever you said that I don't remember. Um, can they file their divorce in North Carolina even though they were married in another state? And then a additional kind of follow up to that, does it matter if the defendant or other party is now in another state?
Okay. So the first part of that question, if you got married, and I'm going to give an example. If you got married, let's say you live in North Carolina, you did a destination wedding in New York City, and then you came back to live in North Carolina, moved to New York, and then you come back to North Carolina and you've only been here for like 2 months. No, you cannot file in North Carolina. You have to have lived in North Carolina for at least 6 months. If the defendant has stayed in New York and you came back to North Carolina and you've been here for years, absolutely you can file. One person has to be living in North Carolina. And let me give one additional example of living in different states. I have someone who comes to me living in New York, New York State, and the defendant lives in Greensboro. I can still file for my client who lives in New York as long as the defendant has lived in Greensboro for 6 months.
Perfect. We'll come back to that one in a second. What do you, what would you do to someone who the other party, the person they're trying to divorce for, get a divorce from, is in like a correctional facility? How do you
You
think
serve
about serving that individual?
Yeah, you serve them at that correctional facility. So and again, I've experienced this in the past 15 odd years. What you do is I will recommend the best outcomes I have had if someone is incarcerated is to serve them by certified mail, return receipt requested, through the USPS mail at the address of the facility, at the facility where they're incarcerated. It takes a little longer to get that green card back, but I've had the most success doing that when someone is incarcerated. And if you
Gotcha.
have if you have their inmate number or some identifying, number or identifying protocol that facility has, that's even better to include in the address portion.
Got you. Do the guide and file forms include that indigency petition you talked about?
They do. So you go through the entire interview, and then they're going to give you an optional section. And that optional section is going to be that petition to sue as an indigent. And then the second part of the optional forms is going to be that affidavit of indigency. So those will be options. And I've gone through the process, so I know what you guys will see if you do the guide and file. So it will have like a pop-up box if you say, no, I don't want to do it. And they're going to say, are you sure? So if there, you will not miss it. They will have pop-ups and, make sure that if that's something you want to do, you can go back and actually do it.
Is the place of marriage the place where the married couple lived or the place where the wedding took place?
Okay, so place of marriage. Let's say in that prior example that you went to New York City to get married on top of the Empire State Building. You put New York City, comma, New York State. That's what you put. Not where you live. Now, again, if you got married, let's say in Jamaica, you went and had a destination wedding in Jamaica, you put Jamaica, or I don't know, think capital, I think it's Kingston, Jamaica. You can put that. But they need to know where you got married. And then if you are concerned about that, where your marriage is registered, that's another option of where you put it. If the marriage was solemnized, meaning it was blessed under North Carolina laws of a marriage in Jamaica, but your marriage license is North Carolina, then I would put in that situation where you got your marriage license.
Is there a time frame if someone's doing service by the sheriff? Is there a time frame that the sheriff has to serve the other person by? Or like if it's been too long, does that then negate the service?
Yeah. So it doesn't negate the service. Typically, in my experience, I've found that they make 2 to 3 attempts. And if you need them to, make an attempt at a certain time, they can't always honor that. They might do their best to try. Like, let's say if someone works like night, third shift, and they need to be served like first thing in the morning, I would share that information with the civil process department of the sheriff's office. I often say, depending on what time of the week you drop everything off with the sheriff's office, give them at least a week to get a sheriff's deputy assigned to that paperwork, and give them at least 3 to 5 days for attempting service. So I always say 10 to 14 days to check in, to call back and say, this is the file number, has this document, have these papers been served? And they'll look up the court file and then give you an option saying, the deputies made 2 attempts and we will make 1 more attempt before we return it to the clerk saying unserved.
Perfect. Can you get that certified copy of the absolute divorce the same day, or do you have to wait or go to a different department, or can you get it from the clerk that same day?
So with that, I'm going to give the answer that's hard for me to give as an attorney. It depends. I will say with the e-court system, it does take a little longer just because they have to key in everything into the court system on the clerk side. And so once that's keyed in, then the civil division, the other clerks, the clerk's office can see it in their system, pull it, certify it, and prepare a copy for you. So I'm at this point, I'm going to tell you what I do in my practice is I wait 24 hours after the judgment of divorce has been entered. And then through e-courts though, I do make the request for a certified copy. So I would say give them 24 hours before you request a certified copy.
Perfect. Another question about service, about the civil summons for the service. A plaintiff would only fill out the first page. The second page would be something for the sheriff to
Right.
complete.
With the civil summons, you want to fill out the top section, and you're going to have to put the defendant's name and address twice, or the defendant's name and then again, below, you'll have to put the defendant's name and address, and then there are going to be two boxes. If you have an alternate address and you're going to do sheriff's service and you want the sheriff to try like their work address, I would put their home address and work address in those two boxes. If you don't have an attorney, you want to make sure you put all of your contact information, because that's how the court will contact you. And then on the bottom left-hand side of the summons, it says name and address of attorney for plaintiff. If none, then plaintiff. You want to put your contact information there, because again, that's how the court will contact you. And so everything on the bottom right quadrant of the form, the clerk will fill out. In the back, you don't touch. That's for the sheriff to fill out if you do service by sheriff.
If someone knows that their spouse has filed a divorce against them, maybe in another state, can they still file in North Carolina?
Typically, and I actually had this experience, someone filed in Maryland the exact same day I filed in North Carolina, and I called that attorney who did that in Maryland, and we had the conversation that since the actual time of filing was prior to when we did in North Carolina, it was first in Maryland. We dismissed our case and they went through the process in Maryland. So typically, I believe a judge would look at that same analysis, or a clerk of court would look at the same analysis. But if that has happened, I'm going to say, for your best bet, contact an attorney from the lawyer referral service, do a 30-minute consult, just so they can double check. And if during that 30 minutes they can contact the other person or the court, the clerk in that other state, to get, their perspective, that might be helpful. But typically they look at who filed first.
Perfect. Last question, which is perfect, because again, we do have a hard stop at 4:30. Someone's just asking if they don't have a current address, have been out of contact with this other party for several years, how should they approach service? So maybe going through those service requirements again really quickly.
Yeah. So, okay. So you don't know where they are. And this is very common. So I don't want anyone to feel any kind of way about this. If you don't know where they currently live, I would say you still need to try to find their last known address. And different ways to do that. When I mentioned the internet, there is a website, and again, this is not endorsed by anyone, this is not an official recommendation, this is what I've seen other people try, is like the People Finder website or White Pages, or if you have an old cell phone number, see if you can do the reverse phone lookup, different ways like that. Sometimes if you have their name and date of birth, or name and social from like a past tax return, if you filed taxes together, you can go on one of those paid searches. They cost, I think some do, I've seen one that was like $40. You can do that online to see what was their last known address. And when you do that affidavit of service, you have to put all of the effort. So you can write in on the form, I use this, this program to get this address. Attached is that the results, and then attach that to your affidavit of service. Now, if you've done that and it's still no service and you have to go to newspaper, you're going to have to do an affidavit of service by publication. And through that, the judge will want to see, did you attempt service by sheriff? And it came back unserved. Then they're going to ask, did you try to serve at a last known address through certified mail return receipt or FedEx? That came back unserved. Then they're going to ask, where did you put this in the newspaper? And with that, I don't think I mentioned it, for newspaper, you have to put it in the legally recognized newspaper of that city or that county. That is the standard paper for service by publication. And then how that will work is they will ask you for the newspaper will ask you for all the court information, the case information, and it has to be published in the newspaper for 3 consecutive Wednesdays. And the defendant gets 45 days from the first Wednesday it's put in the newspaper. And so instead of that 30 days, you count 45 days. And then after that after that third Wednesday, the newspaper will send you the newspaper's affidavit, and then you attach that as your third proof for your affidavit of service, that here's a copy of the legal notice, this is from the newspaper, and I've made all these attempts. It's been 45 days from that first Wednesday, and now I have followed the North Carolina Rules of Civil Procedure, Rule 4. And so then that's enough for the service by publication.
Okay, so we are at 4:30. So I'm gonna have to go ahead and say thank you to all of you for joining with a special thank you to Manisha for presenting. If you would like to review anything that Manisha talked about today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access the recording with or without a Facebook account at www.facebook.com/legalaidnc. The video will be available for about 30 days on Facebook, but you can also watch it at any time in about a week on Legal Aid of North Carolina's YouTube page. If you would like to register for one of our other listening alerts, such as child custody that Manisha mentioned, SNAP benefits, tenant rights, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a wonderful rest of their day.
Thanks, everyone.